Baidoo. Hello, good evening, sir. Welcome to Eyewitness News. So you went to court on an application for committal for contempt. You got what you wanted. How does that make you feel, given that your application has succeeded?
Well, good evening, and thanks for having me. We are elated. We are vindicated as well, because the rules and the laws of the country seems to be working. Yes, it is the case that we filed this application pursuant to the disobedience of the contender to the orders of the High Court of the Republic of Ghana. You would recall that the petition was filed together with an interim injunction. Because of the urgency of the situation, we had to file an application ex parte. And you know, counsel, that this is a strike that is allowed in law. The court ordered that he shouldn't hold himself out as such. Now, he was served with the processes together with the Parliament, the clerk to Parliament. Now, he came to court through his lawyers, even though they had not filed appearance, sought to set aside the interim order. That was on the 3rd. He filed on the 3rd, and on the 5th, which was even a Sunday, we came to court and then argued. Now, the court adjourned to the 6th of January for a ruling, and the court actually ruled that they had not convinced him enough, and so he dismissed the application to set aside the interim order. That was on the 6th, mid-morning of 6th. Now, just from there, of course, so what the court did essentially affirmed the order, that indeed the order still stood as it was. Now, just from there, the contender went to Parliament, and even against the caution of the clerk to Parliament, insisted that he knew the Constitution. He spoke through the minority leader. Eventually, he said he wanted to proceed and then suffer the consequence. So we came, and then we filed the contempt. We got all the documents from Parliament. We last week we moved the application, because when he was served through Saturday service, we were trying to get him to serve. We were not getting it. So we went to the court, and the court granted an application ex parte for him to be served through his WhatsApp and then some other social media handle. He got it and came back to court and sought the court to stay there. He said the court the learned judge should recuse himself for proceeding with the ex parte application for him to be served, because he had filed a certiorari application at the Supreme Court. If you file the certiorari application at the Supreme Court, it means that the judge should recuse himself. Well, so the judge ruled that I cannot rule on my own. If you file something at the Supreme Court, go to the Supreme Court. If the Supreme Court can pass the decision on any day. And so that's what the court said. And so the court said that he should be given another opportunity through the service of a hearing notice for him to come to court and answer the charges with regards to the contempt application. That too, the contender refused to show up. Today, even perhaps today, he asked, the judge said we should serve him after making the argument, and the court adjourned for the ruling of the contempt application today. The judge also insisted that we serve him another hearing notice to come today. He refused. For the lawyer Gary Maku to appear in court that he was representing him. And the judge said, I don't know you. You haven't filed anything. And counsel, you know that criminal contempt is a quasi-criminal matter. The suit number is different from the main petition. The burden of proof is different. So you can't say because you are in the other matter, automatically means you are here too. Especially as the contender is not even in court. So the court said, I don't know you. The contender is not here to even attest to the fact that he instructed you to come. You haven't filed anything. And so I'll proceed to do my work and give the ruling. And the court did give the ruling that he be convicted because the ingredients, as you just enumerated, in a plethora of cases at the Supreme Court, the ingredients as you explained. And so the court convicted him, and because he wasn't there, issued a bench warrant for his arrest. So he appears before him for his sentence. And so that's what we are waiting. The bench warrant has been done, and so we await the service on the Parliament and then the law enforcement agencies outside the precincts of Parliament also do their work. So that's where we are now.
Well, was there a return date given by the judge for the sentencing?
No, there wasn't, because we would not know when he will be arrested. So it is when he is arrested that he will be brought before him. We would not know.
So if he's arrested, he could be brought any day. Is that the case? Or you issue a hearing? What will happen?
Yes, that is so, because you see, even with this case, I am aware that the Chief Justice has issued a fiat to the learned trial judge to sit on every day, including weekends and holidays, until the final decision of all issues surrounding the case. So even if he's arrested on a Sunday, he can be brought for his punishment to be read out to him.
I see. You said Gary Disobey represented him, or sought to represent him today, or purported to be representing him today. On the day that you moved the motion for the committal, was he represented? Was Mr. Kumi represented, or there was no representation for him?
No, he wasn't in court, even though, you see, after he was served with the processes and the learned trial judge asked that we serve him a hearing notice for the day the matter will come up for him to appear. That day, he didn't come. I think earlier, a day before, Gary had filed an application at the Supreme Court staying in the hands of the judge. And he sought to file another one, the same application at the High Court. I mean, all these things we would sort out when we get to the Supreme Court, but I don't want to belabor the point. But essentially on the day, he wasn't in court because he chose not to. He didn't file anything to. But I would suspect that because Gary had filed earlier for the judge to recuse himself for making those orders on the contempt application and same dismissed, they thought that they would not appear. So he himself, he has never shown up in court in the contempt proceedings. It was only today, lawyer Gary, and interestingly, today or yesterday, I was informed that Gary had filed a process, a stay of whatever, and had, fixed the return date to 26, which is next week. So I would only want to hope that because the hearing notice was served on the contempt Ernest Kumi, he asked that Gary come. But that's not the procedure. You first have to file processes. You have to file appearance. You have to, because that's not what happens, counsel. You know this. That's not happen. You have to file something. Especially as you've never been to court on the contempt proceedings. And the contempt, that that the title of the case is even different. It's Republic versus. So it cannot be assumed that it is the same case. No, it isn't. And even with the same case, in the actual case, you haven't even filed appearance. You keep filing processes when you haven't complied with the 9 of CI 47. But that's a different matter for another day. But even with this, you didn't file anything. But you sought to be heard. The judge said, I won't hear you. I won't even record you. My ruling is ready. Because you were not even in court when the matter was heard. You didn't come. You didn't file anything.
I see. I've just seen a copy of the motion on notice application for stay of execution filed by Mafo and Associates, and that's Gary Disobey. That's Gary Disobey. And it says, take notice that Gary Disobey, Mafo Esquire, counsel for and on behalf of the respondent appellant applicant herein will move this honorable court on an application praying for an order to stay execution of the ruling and the issuance of the bench warrant of His Lordship Justice Senyameda, dated 19 February 2025, in the above-mentioned suit upon grounds set out in the accompanying affidavit for such orders and for such orders as the Honorable Court may deem fit. I'm just trying to go through the affidavit in support, and this one, let me just pick some paragraphs for your elucidation. So that on the 8th of January 2025, the respondent appellant applicant had also filed before the Supreme Court an application for an order for certiorari and prohibition, and same has been served on the registrar on the 23rd of January. It's been attached. That despite the pendency of these applications, the High Court, presided over by His Lordship, asked counsel for the petitioner to move the application for committal of contempt on the 13th of February on the blind side of the applicant, despite the pendency of the application referred to in the above paragraphs. And also, the High Court in Koforidua, presided over by His Lordship, delivered his ruling in the above-mentioned application on the 19th January 2025. Attached here, it is marked as Exhibit C, a copy of the letter applying for the said ruling. That the respondent appellant applicant, being dissatisfied with the said ruling, has filed an appeal at the registry of the court. So there's a notice of appeal attached. The grounds canvassed in the notice of appeal raise serious points of law which the Court of Appeal ought to determine. The grounds contained in the notice of appeal are germane and have a likelihood of success, and therefore the respondent applicant humbly praise the court to stay execution and all of that. So this is what he's praying the court to do. Let me see the return. Of course, let me see the return date. There's no return date. Yes, there's no return date. No, the return date is February 28th, Friday, February 28th. So this is where we are. Stay of execution is being filed. Application for stay of execution being filed. And by practice and by the rules, once a stay has been filed, that means that everything stays. So what does that mean for your bench warrant and for the said conviction?
Well, I do not know about this. I have not been served with anything. The ruling happened today, and so if he filed anything after we've left the court, I haven't seen it. I would also want to reserve my comments about the practice, as you say, that once a stay has been filed, everything is stayed. I would want to rest it for now, because we at the appropriate forum, we argue this out. You know what the law is with regards to filing an application as well as an order of a court. I mean, the difference indeed, that once there is a filing of such a process, what it means, that matter, let's put it aside. But you see, I will be surprised. And you see, let's educate the people out there. I know Gary is, an astute lawyer. Look, you file a certiorari application 2 days after you had disobeyed the orders of the court, of the High Court of the Republic, because the order which you sought to vacate or set aside was on the 6th. That ruling was on the 6th. The order was on the 2nd, but you sought to set it aside, and the ruling was given on the 6th. You went to disobey the court. You went to do what you were not supposed to do. And 2 days after, you now, because you were threatened with contempt action, you went to the Supreme Court for certiorari. We've prepared our responses, and it's been filed. Now, what I thought Gary would know, and I know he knows, is that the rules are clear. The authorities are clear. Ex parte, affoda, and then all that. That the fact that you even perceive that a decision or an order is erroneous or is null and void doesn't give you the encouragement to breach it. This is crime. You cannot breach it. Even if you thought that it was a nullity, you cannot. And so this is a quasi-criminal matter. You cannot stay the hands of the court because it is a different matter. It has a different suit number. It has a different title. It has everything different. So how can you stay the hands of the court when he's determining a criminal matter such as contempt? How can you? It's not done anyway.
I see. Let's reserve the legal arguments
I'm
for later.
I'm grateful.
But
we'll meet him.
Sure. By a more substantive point that I just mentioned, but I just mentioned in passing his affidavit, paragraph 8, is that it says that the motion was moved on the blind side of the applicant.
And
on the blind side of the applicant, which means that he wasn't served. He didn't know about it.
He said which motion? Which motion is he talking about?
The committal. Let me read it again for you. So, despite the pendency of the applications, the High Court, presided over by His Lordship Justice Sonia Medahe, asked counsel for the petitioner respondent to move the motion for committal for contempt on the 13th of February 2025 on the blind side of the applicant, despite okay, so this is not a committal, right?
Yes.
Okay.
It cannot be the committal. And it is not an accurate account of what happened. I'm surprised he would put it this way, because that's not what happened. Look, with the contempt matter, they were served with a hearing notice 3 times. In fact, on the day we were in court to argue that, the court said, let me give him another chance. All you needed to do was to come to court. You chose not to come. So which one is the blind side? Look, the law on early utterance pattern is not one of compulsion. It's an opportunity given you. You elect to either, be heard or not. It's your choice. But if you elect not to come and then, speak, to talk about what you know, or you elect not to be heard, nobody can enforce that on you. So if you are served with a hearing notice to appear, and don't forget, this is not a civil matter. It is a quasi-criminal matter. The court could have, even before hearing the matter, ordered your arrest. And so you see, but at the end of the day, this is where we are. The court said, okay, let me give you another opportunity. That you also chose not to come. And then here we are. You still hold yourself as the member of parliament for the people of Akwetia. Don't forget, election is a serious business. It's not just between, and there are copious authorities. It's just between two people. It's a serious, thousands of people divided. And so the court should exert its authority and make sure its orders are carried out. Otherwise, it can lead to a breach of the peace of the area. And so when the court gives a decision, the same court you see, you have been filing things up for the court to make a determination. If it doesn't go your way, you will not obey it. But if it goes your way, or you expect the court to always rule, your way, who does that? So here we are. There is the contempt matter. It has been determined. They were given the opportunity to be heard. The records are there. On 3 occasions, they chose not to. They have not filed anything. You said you just mentioned that they have filed something. The judge directed him to now go and file appearance. Have you seen him file appearance, counsel? I shouldn't ask you questions, but
no, I can understand. I'm sure at appropriate time you have all the processes before you, and we'll make that determination. It's just on Friday, so but
we will meet him there.
Yes.
As for ruling and the fact that an appeal on it, we face it every day.
It's an everyday matter.
Yeah.
All right. Yes, great. Thanks so much, Bernard Bediako, for speaking to
grateful.
us. Lawyer for the 2024 parliamentary candidate for the Akwetia constituency. He's just been speaking to us. So the